everyone, good evening, and welcome back to Thorough Newspaper Analysis. Now, for today, we have a combined TNA for the 4th and 5th of September. So, let's start with the agenda for today first. For our editorial segment, we have an Indian Express article which is titled as One Nation, One Election Plan, How the Constitution is Amended, and When do the states they get a say in the amendment procedure. Secondly, we have the news update segment, and this is going to be followed by the last segment for the day, which is the legal update segment. So let's start with the article, the title of which is One Nation, One Election, How the Constitution is Amended, and When do the states they get a say in this. So let's understand the context of this entire issue first, and then let's dive into the amendment of the Constitution, the procedure that is followed, and this current issue. So let's understand the context. The center on Saturday, which is 2nd of September, it set up a committee to examine various aspects, both legal and logistics, for implementing the one nation, one election idea. The law ministry, it had outlined 7 terms of references for this 8-member committee panel. This committee, it is headed by former President Ramnath Kovind and also includes the Union Home Minister Amit Shah. So out of these 7 points of references, one of the terms of reference is to examine if a constitutional amendment to facilitate simultaneous polls or elections, it would have to be ratified by the states. So here we need to understand that in our constitution, there are different methods of the amendment process. We have simple method, we have special method, we have rectification by state this method. We're going to understand all of these in detail later. But for now, we need to understand that these are the methods. So by this method, we need ratification of the states as well. There are certain provisions in the Indian constitution if we want to amend those provisions, and those are especially the ones which have an effect on the federal character of our constitution. So if those provisions are amended, then there is an extra layer, that is to say there is an extra requirement of seeking approval from half of the Indian states as well before the amendment bill can come into effect. So now let's understand as to how the constitutions are amended in, generally, so to say, across the world. So informally, the constitution, this is amended through judicial interpretation and conventions which are established through uses. So to take an example of judicial interpretation, the process of appointment of judges to the higher judiciary in our country, it would be a perfect example. How? See, our constitution, it refers to a consultation between the president and the Chief Justice of India for the purpose of appointing judges. But the Supreme Court, through its judgment, it has interpreted this term, which is consultation, to mean concurrence. Now, this interpretation, it has led to the evolution of the collation system of appointment of judges, and it has virtually changed the letter of the constitution without actually amending the constitution. So this is an example of informal amendments. Now, if we have a look at the British Constitution and the Constitution in the US, there we can say that the British Constitution, it is considered flexible as it can be amended by the Parliament by passing a law in the same manner as any other ordinary law would have been passed. But on the other hand, in US, if you want to change any article of the Constitution, so there it has to be ratified. The bill has to be ratified by at least 3/4 of the individual states. So that is to say their constitution is rigid. Now the question comes to Indian constitution. So we often say that our constitution has a healthy balance of both rigidity and flexibility. So we have this article which is called Article 368. It deals with the power and the procedure of the amendment of the constitution. The interpretation of this provision, it has been fraught, leading to tensions between Parliament and the judiciary since 1951. I'm sure if you've been reading constitution, you would see that there has been a lot of case laws, lot of amendments, and back and forth between the parliament and the judiciary when it comes to whether the powers under this article it can be used to amend the fundamental rights, whether they can be amended, whether they cannot be amended. The entire trail of case laws that we study in Article 13 and Article 368. So now let's understand the process of amendment. The Constitution, it prescribes three different standards for amending different provisions of the Constitution. There are certain provisions which can be amended by simple majority. There are others which need special majority. Then there are others which need a rectification by the states as well. Let's take up these three methods one by one. Simple majority. There are several provisions in the Constitution which can be amended by following the process which we follow when we pass an ordinary law in the Parliament. So, this is done through a majority of those who are present and voting and does not require any quorum. That is to say, it does not require, let's say, that it has to be passed by two-thirds of the majority. So, it does not require that. There has to be a simple majority of those who are present and voting. Now, interestingly, Article 368, it does not directly make a list of these provisions. Rather, in the Constitution, there are certain provisions which are excluded from the purview of Article 368. If I were to give you an example, Article 4 would be a valid example. And similarly, there are other articles as well where you can find this line which says that no such law shall be deemed to be amended, shall be deemed to be an amendment of the Constitution for the purpose of Article 368. So Article 4, it says that any change which is made via Article 2 and Article 3, it shall not be deemed to be an amendment in as an amendment which is done via Article 368. So that is to say, any change. Article 2 and 3, what do they pertain to? They pertains to establishment of new states, changing their names, boundaries, creation of new states, addition, diminishing in their areas. So all of this, it can be done without an amendment using Article 368. Now let's come to special majority. So for amending provisions that do not fall under first category, Article 368 requires that the amendment bill it is passed in both houses of the parliament by a majority of not less than two-thirds of the member who are present and voting. This term, which is present and voting, the total membership, it is defined under Rule 158 of the Lok Sabha rules to mean the total number of members of the House, irrespective of any vacancies or any absentees at the moment. Now let's understand the third provision. So the third category, it of the provisions, it need not just a special majority to be amended, which means there has to be special majority plus it has to be ratified by the legislatures of at least half of the Indian states. Only after the states have ratified the bill, then can it be amended and it is then passed by the states have ratified, then it goes to the president for its assent, the president's assent, and then the bill comes into effect. So while the two categories, they are not specifically listed under Article 368, the provisions that require ratification, they are often called the entrenched provisions, they are listed out. These involve the federal character of the Indian Constitution. An example of this method would be the Constitution 99th Amendment Act, which established the NJAC, which is the National Judicial Appointment Commission, and we also have the 101st Constitution Amendment Act 2016. Now, there is a case law, which is the case of Quixote Holohon of 1992, where one ground on which the constitutionality of the 10th schedule, which is the anti-defection law, it was challenged. It was that the amendment was not ratified by the states. The amendment, among other things, sought to bar jurisdiction of courts in any matter connected with the disqualification process. So since it affected the power of courts, So it became a part of entrenched provision. This tinkered with one of the six aspects that require ratification by half of the states, which is jurisdiction of the Supreme Court and the High Courts. So the Supreme Court here struck down this portion of the amendment while upholding the validity of the 10th schedule. Now, this is a list of entrenched provision where ratification of the states is needed. Article 368, it lists down six parts of the Indian Constitution that have an additional safeguard for amendment to be done. So these are Article 54 and 55, which deals with the election and the manner of election, the electoral college and manner of election of the president. Article 73 and 162, dealing with the extent of executive powers of the union and the states. Articles 124 to 147 and 214 to 231, which deals with the power of Supreme Court and the High Court, which is also a subject matter of the 1992 case law here. Then we have Article 245 to 255 dealing with the scheme of distribution of legislative, taxing, and administrative powers between the Union and the states. And we have Article 82, which deals with the representation of states in Parliament. And we have Article 368 itself. So these are the entrenched provisions, and via this article, we covered the entire procedure of amendment of the Indian Constitution. And then we proceed now to the next segment for today. And now we proceed to the national news category for today. And here, this is our very first update. India witnesses the lowest August rainfall in about a century, while the IMD forecasts normal rainfall for the current month of September. August witnessed the lowest rainfall in over a century in India, with a 36% reduction compared to the usual amount, which is on an average 25.4 centimeters. August normally receives the second highest rainfall of all the months, and July is at the top. Now, a question might arise as to what is the reason behind this shortfall, and the answer is something called the El Nino effect. Let's understand this term first. See, for that purpose, we go to the Pacific Ocean, and especially the ocean portion of the Pacific Ocean near the equator. On the eastern side of it, we have South America, and on the western side of it, we have Australia and Asia, some Asian countries. Now, usually the water on the eastern front of the ocean water, it is warm, and this warm water is carried from the eastern side to the western side, that is near Australia and the Asian countries, by something which is called trade winds. This is what usually happens. So the water goes from the eastern side to the western side. Now, what happens due to this transition is on the eastern side, we have cold water because the warm water is now being taken away. And from the ocean underneath, the cold water comes to the surface. Now, on the western side, what happens is the ocean water is warm. As a result, the atmospheric pressure, it is low. It causes evaporation, and there's eventual rainfall on the on the western side, where India is also included. This is the usual course of events. However, every second to seventh year, that is to say, this effect occurs every second year, or it may occur every fourth year, fifth, sixth, or seventh year. So then what happens is the trade winds, they become weak. As a result, this transition from east to west is not performed, and as a result, the water on the eastern side is warm, and the atmospheric pressure on the eastern side, it becomes low, and the eastern side receives the rainfall, while the water on the western side, it is cold, and there's no rainfall there. So this is what has happened here. Due to the El Nino phenomenon's strengthening and unfavorable conditions in the Arabian Sea and the Bay of Bengal portion, most of India, it experienced significantly a shortage of rainfall in the month of August. Notably, however, there are some exceptions, which is the northeastern region, the Himalayan states, the parts of Tamil Nadu. And if you remember, a couple of days back, we did a story whereby we talked about the severe rainfall and the landslide situation in the state of Himachal Pradesh. So that is a part here. Now, El Nino, which is characterized by the Central Pacific warming, it typically leads to inadequate rainfall, monsoon or rainfall in India, The last instance of such pronounced August deficits, they were recorded in the year 2005. We also saw a similar situation in 2009, which in fact marked the most severe drought that our country saw in 50 years, with a 24% shortfall in rainfall in the month of August. Moving on to the next update, Tata Power Renewable Energy Limited, it has partnered with Sanyo Special Steel Manufacturing India Private Limited, and this partnership is to set up a 28.12 megawatt green energy plant in the state of Maharashtra. In a statement, it has been confirmed that the two entities, they've signed the power delivery agreement with the Sanyo, Special Steel Manufacturing through its special purpose vehicle TP Alpha Limited. The plant, it is expected to produce 61.875 million units of electricity annually, which could meet the energy requirements of the steel manufacturing unit of Sanyo. The project, it will also reduce Sanyo's carbon footprint annually, and it will be commissioned. There is a likelihood of its commissioning by March of next year. Moving on to a very important update which pertains to the highlights of Diamond League 2023. Neeraj Chopra, he ends in second spot in the javelin throw event, while Sreeshankar, he ends at the fifth position in the long jump event. India's Neeraj Chopra, barely a week after becoming the new world champion, he finished second in the men's javelin throw event at Zurich Diamond League 2023 in Switzerland on Friday. Neeraj Chopra's best effort at the meet was 85.71 meter, which came as his final throw. At the top position, we have Czech Republic's Jakub Waldec, who now has figured at the first position with 85.86 meter. Neeraj Chopra's best throw is 89.94 meter, which is in fact a national record. Also, we have the long jumper, who is Murli Sreeshankar, finishing at the fifth position in his event with a best jump of 7.99 meter. Government, it is to set up 1,000 Khelo India Centres in the country within a year. The announcement for the same has been made by Youth Affairs and Sports Minister Mr. Anurag Singh Thakur. Launching key initiatives on Indian sports in New Delhi, the minister stated that it will not only provide employment opportunities to the former athletes, but this is going to give budding sportspersons a very important chance of taking guidance from the veterans in the field. Mr. Thakur also informed that each player will receive 5 lakh rupees to procure equipments for their centers, and per year another 5 lakh rupees for operational expenses. The minister informed that to commemorate the National Sports Day, around 3,500 events they were observed across the nation, and he has appreciated these athletes of our country for making us pride at the world stage, be it by winning more medals at the World University Games this time than in the 60 years. He has also lauded the efforts and the remarkable, name that 18-year-old Pragnananda has made for our country in the Chess World Cup. The minister launched the third edition of Fit India Quiz, among other initiatives. On the occasion, he also launched an information booklet on sports infrastructure projects which are sanctioned under the Khelo India scheme, as well as launched a National Sports Federations portal. Moving on to the next update. Parliament session from September 18th to 22nd, it has been announced, and there will be no question hour, no private members' business. The Union Minister for Parliamentary Affairs, who is Prahlad Joshi, has announced a special session of Parliament from September 18 to 22nd to discuss important items. There will be no question hour, no zero hour, and no private members' business during this session. President Draupadi Murmu, she is likely to issue an order to summon the House when she returns from her tour of Chhattisgarh. Now, what is a special session of the Parliament when it comes to its legal standing? So for that, we go to the Constitution, and it has to be mentioned at the outset that there's no provision in the Constitution which mentions the term special session. However, we have an article in the form of Article 85, Clause 1, which states that the President shall from time to time summon each house of the Parliament to meet at such time and place as she or he thinks fit, but there should not be an interval of 6 months between the two sessions. So the president usually makes reference to this article for the purpose of summoning a regular parliamentary session. So the same article will be used for the purpose of summoning a special session as well. Now let's understand as to what have been the instances in the past where we've seen such sessions. So for that we go to February of 1977 when we saw special session of Rajya Sabha, which was a 2-day session for extension of the president's rule in Tamil Nadu and Nagaland under the second provision to Article 356 Clause 4. Also, we have 1991 where another 2-day session it was held for approval of the president's rule in the state of Haryana. This is followed by the year 2008 when the left parties they withdrew their support from the UPA government, which was led by Manmohan Singh. So then in 2008 we saw a special session of the Lok Sabha, which was called for a trust vote. Similarly, we saw a situation in 2017 when for the first time a bill it was discussed in a special session in June of 2017. The current government, which was then in power as well, the Modi government, the BJP government, it had called for a joint midnight session of both houses to roll out the GST. Moving on to the next update, which is in this category of defense for today. Indian Air Force, it is to carry out military exercise which is called Trishul. Indian Air Force, it has carried out an extensive 11-day, it has started with this exercise, which is a 11-day intensive exercise called Trishul. It started yesterday, which is on 4th of September. This exercise, it is taking place along the borders with China and Pakistan, involving a comprehensive array of critical air assets. This exercise, it will feature a lineup of key frontline combat jets, attack helicopters, mid-air refueling aircrafts, and other pivotal air assets, including fighter aircraft from air superiority roles to lighter interceptors. Also, interestingly, this exercise, it coincides with China and Pakistan conducting their own joint air training exercise, which is called Shaheen X. This exercise, it has, started taking place across various areas within the northern sector, encompassing Ladakh, the state of Himachal Pradesh, Jammu and Kashmir, as well as Punjab. Moving on to the next update for today. Former Delhi High Court Justice, who is now retired Justice Jayant Nath, he takes oath as the acting chairperson of the Delhi Electricity Regulatory Commission. Justice retired, he took oath as the acting chairperson of the Delhi Electricity Regulatory Commission, and this decision it has gotten the support of the Chief Minister of the NCT of Delhi, and it is to be noted that the term for the former chairperson, who is retired Justice Shabib Ul Hussain, it ended on January 9. This position has been vacant since then. However, now after a gap of around 8 months, Justice Jayant Nath, he is to take charge. Nagaland Institution of Medical Sciences and Research, it becomes functional. So the Nagaland Institution of Medical Sciences and Research, which is the state's first medical college, it has now became functional on Friday with the induction of the first batch of 100 students. Earlier, the Nagaland Medical Commission, it had granted approval for the establishment of the Nagaland Institution of Medical Sciences and Research, which became now the first medical college in the northeastern state since it gained statehood around 60 years ago in the year 1963. Moving on to the next update, NCRT, it is granted deemed university status. The National Council of Education Research and Training, it has been granted deemed to be university status. The Union Education Minister Dharmendra Pradhan, he has announced. The minister made the announcement during his address on the 63rd Foundation Day of NCRT. As the apex organization for school education, the council undertakes various activities and programs, including the educational research and innovation, curriculum development, and development of textual and teaching learning materials. The NCRT, it has been granted the deemed to be university status in the de novo category. A de novo deemed university, it is essentially an institution that can apply to the UGC for setting up a new institution as deemed to be university, which will undertake study and research in unique and emerging areas of knowledge that are not offered by any existing institution. Now, currently, the graduate and the postgraduate programs, which are offered by NCRT's Regional Institute of Education, they are affiliated with local universities like Barkatullah University in Bhopal. We have MDS University, Ajmer, University of Mysuru, Utkal University in Bhubaneswar, and the Northeastern Hill University in Shillong. R. Madhavan appointed the president of FTII Society. The Ministry of Information and Broadcasting, it has appointed actor R. Madhavan as the president of the Film and Television Institute of India Society and the chairperson of the governing council. The tenure of the former president director, who is Shekhar Kapoor, it ended on March 3rd, 2023. R. Madhavan, he is known for acting in films like Three Idiots, Tanu Weds Manu, Rang De Basanti. He also made his directorial debut with the film which is called Rocketry, The Nambi Effect. This has also won the Best Feature Film Award at the 69th National Awards, announced recently. Moving on to the next update, Zomato, it launches AI chatbot for filtered recommendations. Zomato, which is the food delivery platform and the restaurant aggregator, it has introduced a personalized chatbot. This is called Zomato AI. This can help customers choose what they want to order. So, unlike most chat assistants, which respond to one message at a time, Zomato's AI, it allows the user to type in several messages hinting at what they feel like eating. So, this is going to help you in choosing what to order, and this is going to now filter recommendations as per the user choices. And it is going to be available to Zomato Gold customers only. Uday Kotak, he steps down as the MD and the CEO of Kotak Mahindra Bank. In a key leadership change in Kotak Mahindra Bank Limited, its founder and promoter, Uday Kotak, on Saturday, he stepped down as its managing director and as its chief executive officer, effective from 1st of September this year. He will now be associated with the bank as its significant shareholder and a non-executive director. The decision was made following a meeting of its board of directors. As an interim arrangement, the bank will be headed by Deepak Gupta, who so far led it as the joint managing director since the year 2012. This arrangement will remain in place until 31st of December this year, until the RBI proposes its successor. RBI governor, he is ranked as the top central banker globally and is rated A+. The Reserve Bank of India governor, Shaktikanta Das, he has been rated A+ in the Global Financial Bank Central Banker Report Card 2023. The Central Banker Report Cards, it is published annually, that is every year, by the Global Finance since the year 1994. It grades the central bank governors on 101 key countries, territories, and districts, including the European Union, the Eastern Caribbean Central Bank, and the Bank of Central African States, and the Central Bank of West African States. These are the top three who have been ranked A+ with the A+ grade. We have the Indian governor, and then this is followed by the governor of the Central Bank of Switzerland and that of Vietnam. And this has brought us to the international category for today. And here, this is our very first update. US state Georgia, it officially declares October as the Hindu Heritage Month. The state of Georgia in United States, it has formally designated the month of October as the Hindu Heritage Month. And this is to recognize the contribution which has been made by the Hindu American community residing in the state. As per the statement which was released by the governor of Georgia, the vibrant, he stated, and I quote, the vibrant Hindu American community, it has contributed tremendously to the vitality of the state of Georgia by enriching the lives of its citizens. It is pertinent to note that earlier this year, which is in the month of April, Georgia, it had become the first US state to pass a resolution which condemned Hindu phobia. Moving on to another update from UAE. UAE's G42, it launches open source Arabic language AI model. A group of engineers, researchers, and a Silicon Valley based chip company, they have collaborated for the purpose of releasing advanced Arabic language software that can power generative AI applications. The new large language model, which is called JES, it contains 13 billion parameters that was made from a big batch of data combining Arabic and English, a portion of which is from computer code. This name of the generative AI, it is taken from the highest peak of the UAE. Moving on to another update, which comes from Singapore. So, Indian origin economist, he has been elected as the Singapore's ninth president. Indian origin, Tharman Shanmugaratnam, who is a distinguished economist, he has won Sri Lanka's presidential race by or with 70.4% of votes, and he has become the third Indian origin person to head the prosperous city state for the next 6 years. He has been elected as the ninth president of the country, with the incumbent president Halima Yaqub's 6 year term ending on September 13th. Thurman, he was born to Tamil ancestors from Singapore's Indian community, which forms approximately 9% of the over 2.7 million Singaporean voters. By winning the presidential elections, which was held on Friday, the 66-year-old he has joined a long list of Indian origin leaders who are now dominating the politics at world stage and world capitals, including Britain Prime Minister Rishi Sunak, and we have US Vice President Kamala Harris. And with this, we come to the legal update segment for today, with the first update coming from the Honorable Apex Court. So, the Supreme Court has recently allowed an application which was filed by a witness under Section 311 of the CRPC, seeking to call him again for examination. The court allowed the plea while taking a note of the fact that in his initial deposition, there was no occasion for him to bring on certain facts which became relevant after the examination of the expert witness. At the outset, the court cited a catena of judgments wherein it has been made categorically clear that the discretionary power under Section 311, it can be invoked only to meet the ends of justice. The court quoted a couple of precedents on this issue, which held that the power under Section 311, it should be invoked when it is absolutely essential for just decision of the case. The name of this particular matter is Satbir Singh versus State of Haryana and others. And now we move on to the next update, which also pertains to CRPC. The name of this case is Archana versus State of West Bengal. Here, the Supreme Court observed that the power under Section 323 CRPC, it may be invoked by the magistrate even after deposition or the examination in chief of a witness. The key requirement for invocation of the power, it is that the learned magistrate concerned must feel that the case is one which ought to be tried by the Court of Session, the division bench stated. Section 323, it deals with procedure when after the commencement of inquiry or trial, magistrates find case should be committed. Moving on to the next update, which also comes from the Honorable Apex Court, and it also pertains to CRPC. So here, in this particular case, the Supreme Court observed that Section 162 CRPC, it does not affect the court's power to look into documents or put questions to witnesses suo motu to contradict them. The division bench of the top court stated, and I quote, there is, in our opinion, nothing in Section 162 of the CRPC which prevents a trial judge from looking into the papers of the charge sheet suo motu and himself using the statement of a person examined by the police recorded therein for the purpose of contradicting such person when he gives evidence in favor of the state as a prosecution witness. And the last update in this segment also comes from the Apex Court. The Supreme Court, in the case of Union of India versus Manjurani Rothre, has held, or in fact reiterated, that to strike down the provisions of a law or to declare certain rules as ultra vires, there must be a specific pleading and a request for such a relief in the case. The court observed, and I quote, it is tried law that for striking down the provisions of the law or for declaring any rule as ultra vires, specific pleadings to challenge the rules and asking of such relief ought to be made, that is conspicuously missing in the present case. And this has brought us to an end of our TNA. In case you want to get access to the free study materials that we curate or the TNA slides which have been used in this video, please feel free to join our Telegram channel. And for the same, the link is can be found in the description, or you may scan the barcode here. These are the point of contacts in case you want to get in touch with LawSikho. Thank you for being with us.